Hello.
Oh, mine.
Mr. Cross, were you involved in this thing at one time?
What's the style of it, Your Honor?
Barn Grover versus Marion?
I do not believe so.
Well, they had you on the
I've been involved in.
docket sheet. Okay.
Many of them. Sometimes I don't recollect.
Okay, I understand that. Yeah. Says on here supplemental GAL report file 10/22/25.
Yes, there was a motion for custody and Mr. Clark was jail. You asked for him to do a supplemental because of it a few months.
Yeah.
And he stopped.
Getting GAL on Mr. Gardner supports returning the minor children to their mother. Does the cabinet have any objection to that? I wondered if they.
No. Miss Mary was of course already that's all her home.
Yeah. Okay. And y'all still don't have attorneys involved?
No, sir.
Well, I don't know who's gonna prepare the order. Usually the prevailing party does, so.
Originally, you told us, last
Do
time.
what?
Said originally, you told us the last time we were here, we wouldn't have to appear again. You would just sign an order and, but then your secretary called and said we.
I don't
need to
have
be
a
here.
secretary. I have a
Well, somebody
staff,
from the
I have a
courthouse.
staff lawyer, so.
Somebody called from the courthouse and said we needed to come in. You were just waiting.
Well, do you want to completely turn custody back over to the mother? Are you,
Yes, yes, sir.
so you have a job now?
Yes, sir.
Where are you working at?
DoorDash. I'm a dasher and she's got her own
Wait
place.
just a second. I'll call her if I need you to tell her. Okay. You have a separate household set up and everything?
Yes, sir.
Where's that located?
It's in Albany, Kentucky.
Okay. Well, we'll check and see what the last order was. See the GAL report there.
You just want the order concern custody.
Has there been any supplemental or is it modified custody in the file since then?
Now, there was a contempt on the dad, but
Yeah.
I have no faith, yes.
Does the father have any?
Are you to his custody?
Yeah. We have Megan in this case here, that we got in front of us here. The GAL recommended returning custody back to the mother, okay? We're gonna have to draw them an order up to do that. I was just seeing if there were any other conditions in between then that would have to be modified by the order.
Well, there was originally an order adopting the DRC recommendations, which I believe gave them the respondent in custody. And then, or the petitioner in custody. And then, oh, that's it. In August of 2020, and then in September of 2020, there was an order altering, amending, or vacating that order, and it may be intervening respondents. That's the last one. So it'll just have to be break the custody order.
You've had the children for how long? 4 years?
I've had them a total of 7 years. Originally, Danielle had given me a paper.
I don't want to go into the detail. I just
I've
asked you
had
for
them total of 7
7 years.
years, yes.
Well, what I'm wondering is, would we need to make findings and all that sort of thing to do that, or just need to do a simple order?
If it's not contested, so.
Yeah. Well, we'll do a simple order.
Thank you.
We'll do a simple order. It's unusual because of the length of time. That's what kind of confuses me, that under this temporary order because of her incarceration.
That's kind of why you wanted the supplemental.
Yeah, and that's why we got the supplemental GAL, but, okay, we'll enter it. It might be a few days, so you'll have to take a place in the queue, you know, on the line to get it ordered out. Okay,
Thank you very much.
take care of those children.
I will. She will.
Okay,
Thank you.
okay. Lacoste, Smith Carver versus Brett Carver. Yes, sir.
We're here, Judge, with respect to entering a final order in the jury trial that we
You need
had.
to speak up just a little bit.
I said, we're here to enter final
Yeah.
judgment,
Yeah, I'm aware, yeah.
and I submitted a trial order and judgment. The court reviewed it and thereafter set it aside. It had not properly been reviewed by counsel.
Mhm.
So we're here to enter a final order with respect to jury verdict and the application of KRS 364.130 regarding
Yeah, I'm
trebling of damage.
here's my position on that, you know, and I regret that that order was entered in error, causing any confusion. The jury gave you $5,850, and I don't think there's any doubt that you're entitled to recover some court costs. You had court costs of $500 or $600. What was it?
565, right?
I thought it was 600 something.
It was 565.
Yeah,
We
565.
don't object to that, right?
Do what?
We don't object.
Well, I'm gonna order that. I don't think the circumstances in this particular case, that there's applicability of treble damages or expert fees. And, but I will make a specific order of that so you can appeal my decision on that. And the reason I don't feel like that is because I believe the jury, after hearing the evidence, indicated that in this particular situation, the defendant came up and offered to enter into a survey situation and was told by the plaintiff that the line was okay. And then subsequently, after the cutting was done, he goes back up and tells the plaintiff where it is. And then the plaintiff comes in and initiates this action here and wants to get treble damages and legal costs. I just don't think that's what the intent of the statute is. And I think that timber was cut under color of title. That person believed the line was there, did everything that they could. And this would be, I understand how you feel like they could be interpreted the other way, but I just don't see with the de minimis sort of award, the individual has been compensated for the timber and the court costs involved. And I just don't think anything else is there, and that's gonna be my ruling.
You're
wanna
not going to allow any attorney fees?
No, I'm not gonna allow any attorney fees and I'm not gonna allow any expert witness fees. Because I do not believe that this was a torturous sort of cause of representation. Will you submit a proposed order on that, or
I've got one here, I'll let.
we'll let him review it, we'll enter it, and I note your objection to that, and I might be wrong about it, so.
Well, I did want to get on the record, Judge, at least a summary of my argument here today.
Please go ahead and do that.
Judge, in 2017, the statute was amended. And Kentucky treats the wrongful cutting of timber on somebody, just like Texas treats rustling of cattle. It's pretty severe consequences for cutting someone else's timber, especially if you don't give written notice, you don't have certified mail, and you don't have a written agreement between the parties. Those aspects of this matter have been discovered in the case, talked about. Court heard testimony. There was no compliance with the statute concerning notice by certified mail. No compliance with the statute with respect to an agreement between the parties. Now, The statute says regardless of state of mind, it doesn't matter what your state of mind is. If you cut on someone else without giving notice, without having an agreement, you're liable for treble damages in this state. And it's very clear, Your Honor, that that was the intent of the legislature in promulgating this statute. So that business about the pink ribbons indicating a particular line, that was for our purposes. That doesn't mean that they had a right not to give us notice by certified mail or have an agreement between the parties. When they fail to do that, you're liable for treble damages in the state, regardless of state of mind. Doesn't matter what your intent is. You cross over that line without certified mail or without an agreement, you're responsible. And they say that, Judge.
Okay, I've heard your argument before. Now you got it record.
Yeah,
I don't agree with that.
I understand.
Okay, thank you very much.
Thank you, Your Honor.
Thank you, Judge.
Yeah.
Good afternoon, Judge. I'm appearing on behalf of Mr. Hurt. I'm simply here to request a new day for Mr. Hurt. The December motion date, he was unavailable for today.
Your Honor, I would just point out that no response has been filed.
Yes, he says that
You speak up a little bit.
he said, he had informed me a summary judgment had been filed and he is getting a response to the summary judgment.
All right, and are you representing to me that Mr. Hurt says he has some valid defense to the motion for summary judgment?
That is what Mr. Hurt has discussed with me, yes. He says, he had a scheduling conflict.
I'm not worried about scheduling conflict. I accept that you say that. But I think when we get to this time of year, things get a little dicey as far as scheduling and rescheduling things. The Clinton motion day is December the 4th. I want the response to this motion for summary judgment filed with counsel within 5 business days from today. I'm not going to make counsel wait till the next rule day. I would do the same thing for the plaintiff if there was a motion and they made, representation that there was a valid defense. So we will hear this motion for summary judgment in Clinton County on December the 4th.
Thank you.
And if nothing has been filed by that, and any kind of testimony that needs to be given on that to validate this response. So this response motion summary judgment should be filed by the 26th. And that way counsel will give you time to file any kind of written response to that if you want, okay?
Thank you, Judge.
Thank y'all very much.
And to obtain the Zoom link, I'm assuming I need to reach out to Clinton Circuit Clerk for that.
No, you reach my office again.
Okay, thank you, Judge.
My staff lawyer does all the Zooming around here. Okay. Thank
Thank
y'all
you.
very much.